trial, we need to talk about this as well. Talk about the judicial system. The Ghana Bar Association says it unreservedly supports the directive by the Chief Justice, the controversial one by Justice Eni Yeboah, indicating that trial judges ought to observe the age-old tradition of calling cases of senior lawyers first in the courts. Now, the order of the Chief Justice, as we know, means that judges will be calling cases in order of seniority of enrollment of the lawyers, handling the cases without recourse to that notion of equality at the bar. Stating their position in the wake of ongoing debates, the Ghana Bar Association says the directive presents an opportunity for younger lawyers to learn from their seniors. And we have some excerpts of that statement for you. Here you have it on your screens now. The Ghana Bar Association indicating that, and as you see there, referring to that directive by the Chief Justice. And the statement goes on to talk about the fact that the GBA fully and completely associates itself with the subject matter and that reference, and lends full support to the adherence of the age-old tradition and practice among members of the legal fraternity, especially the courtroom practitioners, of calling cases of persons whose names are on the roll of lawyers in order of seniority of enrollment, notwithstanding the notion of equality at the bar. Now, this is their point. The Ghana Bar Association unreservedly endorses the directive by the Chief Justice to all trial judges and reiterates their position canvassed in the Chief Justice's circular that the age-old tradition and practice of calling cases of persons whose names are on the rolls of lawyers in order of seniority, notwithstanding the notion of equality at the bar, presents, quote, a unique and special opportunity for lawyers, particularly those relatively young at the bar, to learn from the rich experience of senior lawyers. So, well, what's informing that decision of the Ghana Bar Association, and why are they jumping into this whole debate, which is highly polarized? Joining us now via Zoom is Xavier Kuja, who's the Ghana Bar Association Public Relations Officer. Thank you so much, sir, for joining us here on The Pulse. So let's start off. You claim that this is about learning from senior lawyers, but there are Ghanaians out there who are also concerned about delivery of justice. Where's the balance, really? You'd have to unmute for us so we can hear you.
Good afternoon, and good afternoon to your viewers.
Right, good afternoon.
I hope you can hear me
yes.
now.
Yes, I can. So I'm asking about the balance then.
Yeah, I don't see any problem with the directive. In any case, the practice is not new. That is why it is even described as age-old. It has always been so, just that some laxity has been shown so far or in recent times in adhering to the practice. Nobody loses anything, rather everybody gains, both lawyers and litigants, especially young lawyers. You see, the courtroom is a special place that you can apply whatever you have read as a lawyer. Many good practitioners will tell you that what you are actually taught in law school and what happens in practice is not the same. That is why they call it practice. So if you are a courtroom practitioner and you meet an experienced lawyer who has a similar case that you have, maybe the facts are different, but the principles are the same, and applies whatever you have read in a way that you have not done before, you would agree with me, you'll be a better person. So we stand by the position that under no circumstances should we compromise on a situation where lawyers can learn from each other.
I mean, it's as though, and Xavier, while we make this point, kindly look into the camera for me, your camera, and it's as though the point you're making now is that you're turning the courtrooms into a steady field. This is about justice, delivering justice to the people. You're compromising on that leg of it by supporting the Chief Justice's directive, isn't it?
Not at all. It has always been so. Because as I said the last time your radio station interviewed me,
right,
there are so many things that you cannot read from books. You learn them only in the courtroom. Assuming you are doing cross-examination, the kind of questions that you ask, how you ask the questions, you can only learn them from somebody who is doing it. There are certain questions when you ask, you rather empower or tool the witness to reach constructive case. And that shouldn't be the case, because you are doing your case, and yet you are giving the tool to a witness to build up on this case. And these are skills that can only be learned in the courtroom. You can't read them in books and apply them excellently unless you see people in practice doing it. And let us not get it wrong. The practice has always been that senior lawyers' cases are called before junior lawyers, but junior lawyers can always make applications to seniors that they want their cases to be called. You can only tell them, and they will allow you. And judges themselves can also say that, oh, seniors, there is this case before me that I think that needs some attention. Can you bear with me? I want to hear him before. It is always done. So the impression shouldn't be created that once this circular is issued and you have, issued this statement, then from today onwards, the tradition is going to be that once you're a senior lawyer, your case must be called before a junior lawyer's case. That is the ideal situation. But if the need arises, as I explained, for a junior lawyer's case to be called before that of a senior, why not? Because the courts must also manage their cases. But convenience must not take the place of the tradition. That is what we are talking about.
So where's the priority really? And I guess that's the concern, because if the Chief Justice is now alarmed about this, obviously something must be informing that decision. What do you think is informing that decision?
What is informing the decision is that it appears now judges are not adhering to that. They take cases that they like, or they just allow anybody to make that to take his case. And the Chief Justice's position, as endorsed by us, is that it is the best of practice, as has always been the case, that the most experienced lawyers should have their cases heard first, to afford the younger ones or relatively younger ones at the bar to have the opportunity of learning how those things are done, especially in advocacy. How you even present your case is very important. The kind of words you use, the diction is very important, because you are working on somebody called a judge who will listen to you, who doesn't know your case. You are presenting your case to be able to be convinced that you have a case to rule for you, or otherwise.
And this is what the problem is.
So
correct me if I'm wrong. Some trace all of this to the basic problem about the rigidity of the judicial education system. You're failing to open up the system and to allow for a fresh, what some experts will term fresh birth, which would afford the opportunity for a better form of training in the judicial service. You're not doing much of that, and now you're trying to fix the problem at the very end, the point where we're expecting that justice will be delivered.
I think that legal education should be separated. It's a distinct thing from and separate from courtroom practice.
But you're talking about learning. That's what you referred to.
Yeah, learning. Yes. Yeah. Because the question you asked me borders much more on legal education.
Right.
You agree with me? So I'm saying that as far as training of lawyers is concerned, that's not what we're talking about. You may have had the best of training, but we're saying that learning continues. As far as you decided to become a lawyer, you are a student for life, you like it or not. Because there are new things coming up every time. The only time you update yourself properly is when you see seniors applying the law in court. Because even the procedure to be adopted, you can read it, but you don't know when to apply it. It is when you see somebody in action that you know when to apply it.
Well, I'm not a lawyer. I'm not a lawyer, but correct me if I'm wrong on this point. You have the option of, is it pupillage after your professional legal training? Why not place emphasis on that period and strengthening that opportunity to make sure that these young lawyers learn some more from their seniors?
Yes, that is already in place. And if you care to know, that is actually a position by law, or established by law, that every lawyer that passes out of Ghana Law School, Ghana School of Law, should have a 6-month compulsory pupillage. Beyond that, you cannot even take on a junior should you decide to set up your firm until you are 7 years. What it means is that, of course, you are required to have some level of experience, and that experience doesn't come on a silver platter. It doesn't just come on sitting in your office and reading whatever you want to read and think that is all. Because as I said earlier, we apply the law in the courtroom. So, in as much as you do PPL, that doesn't end the training. I believe after journalism school, you have some training before you are put on this program. You didn't just come and after interview, maybe after graduation, the next day they gave you this job and say, okay, you can host this program. I am sure that was not happening. Just because they believe that even though you trained as a journalist, you still need to learn on the job. So courtroom practice, as far as courtroom practice is concerned, allowing seniors cases to be called before juniors cases is just learning on the job, so to speak. And law is much more about learning on the job.
But by the statement that you're issuing, there are those who accuse you of endorsing injustice. How do you respond to some of these claims?
I don't see any injustice in this case. I believe, should you have a problem, a legal problem, you want to have the best service, not so. So if we are encouraging a system where lawyers will learn a lot of practical things to be able to deliver the most or top-notch service, why should anybody be concerned? I think we should rather be applauded. Because in recent times, you may have heard that people are complaining and standards in legal practice have fallen. These are some of the measures that can be enforced so that we get back to where we were.
Why is the Ghana Bar Association not asking the judges to partly take responsibility for this, particularly when we know that the Chief Justice himself serves on the Judicial Council? He has the opportunity to correct whatever anomaly there is in the system. Why is it not failing? Why is he not admitting the fact that probably something may have gone wrong at their end as well?
No, you see, let's be fair to the Chief Justice and to everybody and to ourselves. Look, the judges have their courts. They man the courts. They must manage their cases. So they can decide this is the way I want to go. But in the course of doing that, you may be harming the system by not following the tradition. That is why the Chief Justice came up to say that it should be followed. If you read the circular carefully, part of which we have even quoted in our statement, it is clear that judges have the opportunity to man their court at their convenience, but not at the expense of the well-established tradition that we have all inherited, because there are inbuilt benefits for both litigants and lawyers.
Interesting.
So for us, any day, any time, we endorse this practice because it doesn't harm anybody in any way, both lawyers and the general public.
At least some are saying most of you within the Ghana Bar, and particularly the executives, are endorsing this largely because you're seniors. So yeah, it favors you, favors your chambers as well.
Oh no, I think that they are getting it all wrong. You see, let us not understand the circular to mean that if I'm a senior and I have a case in court, my case will be singled out, heard, judgment delivered before they come to yours. We are talking about a regular day in court when a number of lawyers are sitting at the bar. Then a judge will come out and say any applications. The moment a judge says any applications, it means that the most senior will have to make application. But if a junior has already spoken to the seniors can go ahead. So sometimes the judges may not even be aware. They ask, have you asked permission from your seniors? They always ask. So there's not anything wrong. And there is nothing new about this. I don't know why people are even worried.
Okay, Xavier, give us examples of similar practices elsewhere. You operate within the Commonwealth system, and there are many out there who are wondering, well, do we have a similar case elsewhere, perhaps in the UK or other Commonwealth country? Is this the same practice, something they do?
Yeah, I can tell you about the UK because if our tradition is well steeped in the UK system. The wig and gown, for example, that is where we pick it up from. So many of the things we do here are from there. Our case law used to be a lot foreign-based. Just that now our Supreme Court has come up with a lot of local cases. So these days, you don't even hear Ghanaian lawyers citing foreign cases. So these practices are not new to those jurisdictions too. I'm yet to know of a profession that would say that young practitioners of the profession shouldn't understudy the more experienced ones. Take the medical profession, for instance. Even your profession, I'm sure as you are hosting this program, there's somebody standby. A day that you not be able to come to host this program, somebody will step in. Why? That person may be a Guinea person, but because the person understudied you. Because you don't want to dilute the standard. Is that not so? It's the same thing we are doing, and there's nothing new about it. It's an age-old practice, and we don't want to go away with it. We will not compromise on that.
Is this an admission of the fact that the Ghana Bar Association believes that the standard of training of persons within the judicial service, particularly lawyers, the standard is actually falling? Are you admitting that fact? Because that's not clearly stated in your statement as well.
I think it's a general problem in the country. Every profession, in your profession, I think that you also
you're unfairly being, and I'm sorry, Xavier, but you're unfairly being fixated on the media. Why not focus on the judiciary? Today is your day. We're focusing on you. Precisely. So are you admitting that the standards are falling within your system?
Of course. And I say that it is a national thing. Even moral standards are falling in this country. So I cannot say that legal practice as I met it 17 years ago is still the same. Something has changed. Look, let me give you this scenario. When we were called to the bar some 17 years ago, vacation time, which was supposed to be a free time for even junior lawyers to work well, you would sit in court and your case would be called at 4. All because we're learning, we're observing the tradition. But now you go to court, you see a fairly new lawyer, maybe 1 or 2 years, he's even trying to struggle to make application. When you close from court, you see them at the forecourt just chatting. So we advise them the best strategy is to sit there. Sometimes if you have nothing to do, serious to do in chambers, come to court and listen, especially in the superior courts. Because you will never go away not learning anything.
The young lawyers are not willing to learn?
Yes, it's a general thing in Ghana. You don't want me to refer to your profession, but any well-meaning Ghanaian will tell you that it's a national problem. Every young person in Ghana is in a hurry, and we don't know where we are going.
Interesting, but let's look at this. Right, just go ahead.
In the legal profession, I always tell people that wait for your turn. Just learn at the right time. You will get the recognition, and the recognition will not come from outside. It will come from within the profession, because it is us lawyers who know who are the best lawyers. No, if it is not by a lawyer who can talk, who can say that, it is the lawyers who know who are the best lawyers. So you learn. When the opportunity comes, we'll recognize you.
Some say your seniors are even complicit in the following standards. Just recently, the Ghana School of Law was engulfed in a number of malpractices as well. Admission into the law school, we understand, has been compromised by at least 1 or 2 cases. That's proven. Right, that's been admitted even at the disciplinary level as well. Some of these activities are believed to have been, contributing to the falling standards within the judicial education system. What's your take on strengthening the Ghana School of Law and by extension legal education in Ghana?
Now, are you asking my view as a representative of the bar, or you want me to speak for the law school? Because I don't speak for the law school.
You speak for the Ghana Bar Association. This is a development that should obviously concern your association as well. You agree?
Yeah. I speak for the Ghana Bar Association.
Because you are creating the impression that young lawyers are not interested in learning. I'm saying sometimes you, the seniors, are also complicit in this. We've had a case where at least someone was admitted into the law school who's not qualified to be there. That's a matter of public record. You agree?
If I say that young lawyers are not interested in law school, it's not the same as saying that law students are not interested in learning learning. Because we are talking about young lawyers, and I'm a PRO for Association of Lawyers, not SRC of the law school. That is why I'm asking you if you're asking for my personal opinion. Because I'm speaking as a rep or PRO for Ghana Bar Association, not PRO for all SRC president of the Ghana School.
This is a school
because we are lawyers, we are law students.
This is a school that would churn out lawyers that you certify. You're not concerned about the training process?
We take the end product. So I agree with you. We have to be interested in whatever products come out. But the processes involved in admissions and what have you do not go to the Ghana School of Law. They do not go to the Ghana Bar Association. So I think that is an unfair question to me.
Are you not being evasive? The Ghana Bar has been silent for quite too long.
I am not being evasive. Because you are saying that I said young lawyers are not interested in learning. I didn't say that law students are not interested in learning. So if you decouple your question and move away from linking it to my statement that I made, I believe
Xavier, it's a matter of standards, isn't it? You've been silent. We've not heard from the Ghana Bar Association on some of these developments within the Ghana School of Law, you agree?
Which development is that?
What I was just referring you to. You didn't want to comment on that.
Namely?
The practice of admitting
that the law students are not interested in learning.
A law student was admitted who's not qualified to be there. Some of these practices, you agree, compromise on the quality. That's what I was asking earlier.
But those are purely administrative issues which the Ghana Legal Council has taken steps on. So I am not positioned to comment on them at this point.
Anyway, I understand
because
your situation.
No formal decisions have been communicated to us, as far as I'm aware.
All right then. We'll definitely be in touch with you, but I'm grateful that you've been able to spend some time with us. Xavier Kujeb speaks for the Ghana Bar Association. Thank you so much, sir, for your time.